morning, everyone. Ladies and gentlemen, I am Olubukola Temitope-Ojuri from Nigeria, Lagos, from the law firm of Therapeutic LP, and today's session is going to be on amendment on patent law and recent case laws. And the speakers for today's programs are Dr. Kristen Grunberg, partners, patent attorney at Grunberg's and Mayers, PLLC USA, and Gerard M. Murphy, partner in Birch, Stewart, Kolash, and Birch LLP Partners USA. Can you please come up on stage, please? Thank you. So I'm quite sure and confident that today's program will leave everyone with a boisterous information on amendment in patent law and patent infringement cases. And as I kickstart today's program, I would like to bring up on the podium our first speaker, Dr. Kristen.
Yes, I'm ready.
So, question and answers will be taken at the end of the presentation. So you have 15 minutes.
Hello. All right. So this next presentation, I guess the whole session that we're handling goes in a quite different direction. We are talking a little bit about recent developments in pharma case law and also what happens at the patent office in terms of pharmaceutical inventions. And how many of you are actually dealing with pharma cases? Okay, so quite a few. Oh, that's good. Excellent. So I think I have much more slides than I will actually get to. So I think I will limit my 15 minutes that I have to talking about patent eligibility of method of treatment claims. And there's some very recent case law, the Vanda Pharmaceuticals versus Westward Pharmaceuticals case. And the case actually prompted the patent office just about a week ago to issue a memo guiding the patent examiners in their treatment of or in their examination of method of treatment claims. If we have a little more time, then I want to sort of take it a step further. There's a reference in the Vanda case distinguishing it from what happened in Mayo and Diagnostic Claims. And all of you who are dealing with pharmaceutical claims, I'm sure you're quite frustrated by the confusion that exists with respect to 101 case law and specifically getting anything allowed at the patent office that has a 101 rejection. Okay, so just for those who may not deal so much with the patent aspects here, of course, in the US, under Section 101, anything new and useful, process, machine, manufacture, or composition of matter can be patented. And for many years, it was fairly easy to get these types of claims allowed. But there's a large body of case law over the recent years, and I'm not going to go into those details because I'm sure you're all quite familiar with those cases. But Mayo versus Prometheus and the Myriad case, it dealt with, on one hand, diagnostic methods, and on the other hand, the patenting of isolated DNA. Those really laid the groundwork for what is now happening in the courts and caused much confusion at the patent office. And the patent office addressed the cases with issuing various guidance. And how many of you that do pharma do know the life science examples and composition of matter examples? Yeah, okay, some at least. Okay. So there are two memos that are very, very recent, and one of the issues was addressed in the April 19 memo based on the Berkheimer case, and it addresses the limited question of whether an additional element represents a well-understood routine or conventional activity. And then the Vanda memo emphasizes that method of treatment claims can be found to satisfy the first step of the Alice-Mayo analysis without requiring a showing of a non-routine or unconventional step. Now, question is, well, what is this analysis? The two-step analysis under the Patent Office guidance based on the Mayo case and the Alice case is, in the first step, the patent examiner is supposed to look at is a claim directed to a process, machine, manufacturer, or composition of matter? And if the answer is yes, then proceed to step 2, which is really 2 steps, 2A and 2B, to determine whether a claim is directed to a judicial exception, meaning a natural product, a law of nature, an abstract idea. And then the question is, does it recite additional elements that amount to significantly more than the exception? And that's sort of the threshold of getting anything allowed at the Patent Office. And it sounds very easy here, but nobody really fully understands. And most importantly, the examiners usually don't fully understand what the significantly more really encompasses. So therefore, we have all these additional memos guiding the examiner. Now let's talk a little bit about the Vanda Pharmaceuticals case. So one potential side effect of a compound called iloperidone is the prolongation between the Q and T waves of a patient's heart rhythm, and that can cause serious cardiac problems. Now, during the development, it was discovered that a mutation of a specific liver enzyme caused poor metabolism of this compound and was associated with an increased risk of this QT prolongation. The discovery resulted in the 610 patent, and it claims a method of treating schizophrenia comprised of identifying patients with this particular liver enzyme mutation and then giving them a lower dose of the iloperidone, 12 milligrams versus 24 milligrams, and thereby mitigating the potential QT prolongation problems. So here is a claim. It's quite an involved claim, but we can, break it down. So method of treating a patient with iloperidone, and the patient is suffering from schizophrenia. So what are we doing? We're determining first whether the patient is a poor metabolizer of this liver enzyme, and if the patient has indeed a poor metabolizer genotype, then supposed to be internally administered iloperidone to the patient in the amount of 12 milligrams or less per day. And if the patient does not have this particular genotype, then much more, up to 24 milligrams per day are administered. And then here it comes, we're in a risk of QT prolongation for a patient having the poor metabolizer genotype is lower following the internal administration of the 12 milligram or less than it would be if obviously the higher dose would be administered. Okay. Now, under the two-step analysis, the question is whether the claims at issue are directed to a patent ineligible concept, a law of nature, abstract idea, or natural phenomenon, and then whether the additional elements transform the nature of the claims into patent-eligible subject matter, something that is more than routine or conventional steps. And in this case, the majority found that the claims were not directed to patent-ineligible subject matter at the first step of the Mayo framework, acknowledging that the inventors had identified a law of nature, but found that the claims were directed to an application of that relationship, namely to a method of using the allopurinol to treat schizophrenia rather than the relationship itself. For those of you who know the life science examples, you probably find this quite interesting. Now, the patent office, so the case was decided in April of this year, and the patent office found the need to provide a memo to the patent examiners. And the reason, the background really is that many method of treatment claims do get 101 rejections from the examiners. And it is very difficult in most cases to get the regular examiner who works on a case getting these allowed. So normally the way to handle such cases is to have an interview and invite. There are a few very specialized examiners who deal with 101 matters. I don't know how many of you know about this. And those examiners know the case law very well, and that's really the only way, other than appeal, to get many of these claims allowed. So the patent office, with this memo, is hoping that the allowance rate for method of treatment claims actually will go up. And so they're emphasizing that method of treatment claims can be found to satisfy Section 101 at the first step of the Alice-Mayo analysis without requiring a showing of routine or unconventional steps. And they're basically saying that the claims were patent eligible because they were not directed to a judicial exception, stating that while the invention may have stemmed from a recognition of naturally occurring relationships between the allopurinol, the liver enzyme metabolism, and the QT prolongation, the inventors did not claim the relationship, but rather claimed an application of that relationship. So the claims were eligible under the first step of the Alice-Mayo framework because they were directed to a method of using the allopurinol to treat schizophrenia, rather than being directed to a judicial exception. The claims should be evaluated as a whole. That is the guidance to the examiners. I'm not sure they always actually do that. And despite the administering steps, the claims invalidated in Mayo, so this is a contrast to the Mayo case, were not method of treatment claims that practically applied a natural relationship. Thus, the Mayo case does not undermine the eligibility of method of treatment claims. So I think that's a very important statement in the memo, in the Vanda memo. And when determining whether claims are directed to a judicial exception, there's no need to consider whether the recited steps are routine or conventional. And if the claims are not directed to a judicial exception, there's no need to undertake the analysis. Now, let's see, I probably have like 3 more minutes. Okay, so let's just briefly talk about what the question that is raised in terms of diagnostic claims, that comes up from the Vanda case. So the memo casts some further doubt as to the eligibility of diagnostic claims because it characterizes the ineligible claims at issue in the Mayo case as having an overall diagnostic focus. Now, for that, and some of you know the life science examples from the Patent Office, but for that, I just want to draw your attention to the confusion that exists with respect to diagnostic claims at the Patent Office. And so here we have, this refers to example 29 of those examples. And in Claim 1, there's a recitation of a method for detecting Gileadus with a specific Gileadus antibody called JUL1 in a patient by screening for the antibody in a sample of the patient's plasma. And then step 2, Claim 2 actually adds an additional step, namely diagnosing the patients with the Gileadus when the presence of the Gileadus antibody is in the plasma sample detected. And otherwise, Claim 2 had exactly the same language as Claim 1, with the exception of reciting diagnosing the Gileadus in the preamble instead of detecting the JUL1. So despite the similarities of these claims, the Patent Office came to quite different conclusions, namely that Claim 1 would be eligible for a patent, but Claim 2 would not be, even though it had an additional limitation. And Claim 1, according to the Patent Office, was not directed to a law of nature and was therefore patentable. But the addition of the diagnosis step in Claim 2 introduced a reliance on a natural law, namely the correlation or relationship between the presence of the JUL1 in a patient's plasma and the presence of Gileadus in the patient. So still much confusion with diagnostic claims, and not so easy to get those allowed, but a little bit of hope for method of treatment claims. So with that, I think I finished my part.
Thank you, Kristen. And now we'll now be bringing on the podium Mr. Gerard Murphy from BSKP.
Thank you.
Thank you.
Thank you for the very good treatment of patent eligible subject matter. That's a very important issue for any of us who are working with biotech, pharmaceutical, and a lot of other types of inventions. And it's a frustrating thing, so thanks for covering that today. So I have 3 points, or 3 kind of general topics that I wanted to cover in this 15 minutes. I've decided I'm going to only try to cover the first 2, and I'll be lucky if I get through those. So I'll try to go through them pretty quickly to try to make the points that I want to make. So the three points I was going to talk about is insufficient description for broad claims. For your patents, you always want to get broad claims. In the biotech era now, the last 20, 30 years, it's getting harder and harder to get broad claims, especially excuse me, in the biotechnology patents. So I'll talk about a recent case dealing with that in a very techie kind of setting. Then I'll have some general comments on PTAB trials in pharma cases and why what the advantages and disadvantages of those. And the last point probably will not get to, so I'm just going to skip that for now. So insufficient description for a broad claim. In the United States, we have basically 2 ways to challenge an besides putting aside prior art for now. If the claim's so broad that it reads on the prior art, you're not entitled to it. But beyond that, there's 2 main ways to challenge an overly broad claim. We have something called the written description requirement of 35 U.S.C. 112. And in my mind, there's kind of two variations of written description problems. One is when you put new matter into your claim. That's basically prohibited. You've got to stick with what's disclosed and use more or less the same words that are in your original patent application when you're writing your claims or amending your claims. I'm not really going to talk about the new matter issue today. And the other is insufficient support to show possession of the claimed invention. Even though the exact words that you're using in your claims are describe, verbatim in your original specification, there may not be enough technical support to support the broad claim. So, the patent attorney wrote those claims, but the inventor didn't really invent something that's that broad. And therefore that claim can be subject to a written description challenge. Then we have something called enablement, where the patent application must teach how to make and how to use the claimed invention. And again, if you've only taught how to make and use a narrow scope, you shouldn't be able to get the broad claim. So there's one case I wanted to talk about briefly, and I'm going to kind of go through this quickly. It's a fairly recent case, and anybody in here have familiarity with therapeutic antibodies? Okay, we have one, so I'm going to try to couple. This is a therapeutic antibody case. These drugs are huge in terms of market share, and this was a case between a couple pretty big players, Amgen and Sanofi. And I won't bore you with all the details, but the invention related to an antibody that bound to a particular biological molecule or receptor. Has to do with low LDL cholesterol. There's probably maybe one or two people in this room that have high cholesterol, and so it's a drug to help treat that. And this is sort of the technical mechanism that is involved in the drug they came up with. It's actually an antibody. Amgen was sort of the first company to start researching really in this specific area, and they developed a product called Repatha. They also filed the patent at issue, so they were kind of the first company to come along. The second company was Sanofi, and they were the infringer in this case. They developed an antibody that did something very similar or the same, but it had a different structure. And they also were partnered with two other companies, Regeneron and another company. The problem with this case, and we're seeing this a lot now, there's a lot of litigation in the therapeutic antibody space where patents are being invalidated for lack of sufficient written description to support the broad claim. And I'm going to walk through this claim even for you non-pharma types, just to hopefully you can understand a little bit what this is an issue in this case. So it's an isolated monoclonal antibody wherein, and so an antibody is like a molecule that, we'll say it looks like this, in reality it's kind of like a Y shape, and that it binds to something. And so they're claiming the antibody, but how do they claim the antibody? They claim the antibody to what it binds to. So it binds, let's say it's got 4 knuckles here, it binds to this knuckle or this knuckle or this knuckle or this knuckle, one of these 4 locations. It doesn't bind to this part or this part or this part or this part. So they're claiming it by what it binds to, not by its structure. And they had examples of antibodies that actually, they gave the full structure of the antibody, but the actual structure of the antibody being claimed was really kind of undefined, at least with respect to what it binds to. And then it talks about the antibody blocks the binding of this compound to another compound. So it talks about where it binds, and it talks about what it disrupts, what kind of other bindings that it disrupts. But it doesn't tell it what the compound is or what the antibody is. So the patent was challenged for failure to comply with the enablement and written description requirements because the claim was broader than what was supported in the specification. And the jury the jury instruction in this case was, and this is what they told the jury at the end of the trial, in the case of claims to antibodies, the correlation between the structure and the function may be satisfied by the disclosure of a newly characterized antigen. If you find that the level of skill of knowledge in the art of antibodies at the time was such that production of antibodies against such an antigen was conventional. So basically, they said you can get a broad claim. They're basically telling the jury you can get a broad claim if people knew how to make antibodies at the time. You describe one antibody, you talk about the structure and the function, and if you're dealing with a new antigen, which this is the antigen that it sticks to, if this is new, you should be able to get a claim to a broad antibody. And that's there was some old case law, patent office practice, a lot of old patents where they basically, if you get a new antibody, if you characterize this new antigen, you can claim any antibody that binds to it. And that was what the jury was told. On appeal, that jury instruction was overturned, and they ended up sending it back for a new trial. And the holding in this case was, the problem with the instruction was it allowed the jury to dispense with the finding of written description of the invention. There wasn't a description of the invention in the claim. There was a description of what the invention of the antigen, but not the antibody. Again, the invention was the antibody, not the antigen. So, and again, it gets into a lot of detail. So if you're really interested in this, you might want to read this case. I can answer some questions later, but it was reversed and remanded for a new trial. And they told them to give a new jury instruction, and the challenger of the patent, in this case, the patent was held to be valid and infringed. And the infringer said, this isn't fair, this isn't fair. The claim's too broad. It doesn't tell what the invention is, it just tells what it does. So they sent it back for a new trial and gave them an opportunity to put on evidence in the new trial to show lack of enablement. Okay, so I'm going to just skip through this. If you're really interested, you can take a look at those other slides. We have some guidelines that came out. Patent Office is really good about coming out with guidelines, as it was mentioned in the previous talk, quickly after a major new case. So Patent Office came out with new guidelines on how examiners should determine whether claims are supported, broad claims are supported. Okay. Next point I want to talk generally is about PTAB trials in pharma cases. So for years, there was a lot of most of the I'll call it chemical litigation was between chemical companies. Early in my career, very few pharmaceutical companies were suing each other. Now, for the last 10, 15 years, pharmaceutical companies are suing each other all the time. It's just a huge business, and they're getting much more aggressive with their patents. So if you want to challenge a patent, what are the advantages if you're the challenger of using a PTAB trial, which Patent Trial and Appeal Board, you're challenging it at the Patent Office versus challenging it in court? It's faster, cheaper. Part of the reason it's cheaper, a major part, is limited discovery, and that the PTAB judges will understand technical arguments and they're familiar with the case. Now, if your argument is technical, you may want to be at the Patent Office. If your argument is more fairness, emotional, social justice, whatever it is, you may want to be in court. So disadvantages for the challenger. The PTAB is not generally persuaded that much by the argument or the inference that the patent owner is this big bad pharmaceutical company that's causing high drug prices. You see this in the newspaper, you see it in the news, congressmen are talking about it. Juries or judges might be influenced by that a little bit. Patent Office is not going to be influenced very much by that kind of good guy, bad pharmaceutical company type of argument. They really are interested in the science and the facts and the patent law. So you'll get a kind of dispassionate ruling on your case. Depending on how old the patent is, you may not be able to raise 101 or 112 arguments at the Patent Office. You may need to go to court for that, but you can challenge based on prior art. You're not going to be able to resolve any infringement issues. This is only validity, and maybe only validity over prior art and some other issues. And so if you don't get what you need out of the Patent Office, you may end up in court anyhow. But if you can knock the patent out on prior art, as the potential infringer, your problem has sort of gone away, and you don't end up in court, or you can stay the court case. So this is some statistics on technology where we're seeing activity with the chemical biopharma field. So you can see electrical computer is more than half of the cases. Biopharma is more than chemical. So there's a lot of activity in the biopharma space. If you're trying to attack a patent, you're usually going to get it. The trial will normally be instituted. There's a two-stage process. Will you institute the trial, and then once it's instituted, what's the ultimate result on that? So I want to give you a case study. I think it's helpful to just kind of see how this can play out. And this was the first biopharma case that worked its way through the patent office, and it was actually one of the first pharmaceutical cases. And I think it's good because it shows I'm going to try to talk about how a court might view this case versus how the patent office might view it, and the types of arguments. I'm not a district court litigator. I don't go to trial. I don't argue before judges in court. But I've worked with a bunch of litigators. I've been in court. I've been on the witness stand a couple times, more than a couple times. I've been deposed, so I kind of watch what those litigators do, but I'm not one of them. So I have a little bit of a feel of how these things play out in court. And in this case, there was 3 IPRs filed on the same day against 3 patents owned by 2 companies. So Genzyme owned 2 patents, Duke owned 1 patent. And the invention, they were all method of treatment claims, method for treating a particular disease called Pompe disease. And they administer an enzyme to the patient. It's basically a drug. And the patients have a genetic disease so that they are born with a genetic defect, and they will probably die at a pretty young age if they don't get this. So in this case, actually, the invention at issue was a subject actually of 2 different media type things. There was a book called The Cure, and this is a real life story. And then there was a movie based on the book, and you can see Harrison Ford there on the right. So I think the emotional side of this could really, if this case ended up in court, it could really play out differently in court than, say, it would at the patent office. So if this case went to court, this is this is a disease that affects children. They end up in a wheelchair. Their heart stops working, their muscles don't work, and they die if they have the bad form of the disease at a very young age. So how would a jury respond? So was the jury going to think the innovator, the patent owner, they're great, the inventor was great, saved these children, came up with this new therapy, and if they think that the patent owner is or the inventor is a great person, that influences the whole case. Or will they think, this is a great patent, but it's so expensive. This drug costs $300,000 a year. So maybe they think this patent's no good. This should be knocked out. So everybody should be able to use this. And maybe they want to rule for the second company, the possible infringer. So there's these emotional, social considerations that can really have a big influence in a jury trial, or maybe even a little bit in a judge trial. In this case, it was all about the science and the technology and the evidence. It really, the emotional side of it really isn't very persuasive to the patent judges. So in this case, it turned out that all 3 patents were invalidated by the patent office. And I'll just have some more information on this. So anyhow, my main point is, if you're in the pharma space and you're trying to decide what to do, using the patent office trials to knock out your competitor's patent may be a better choice than going to court. And it might not be. It just depends on your particular case.
Thank you, Gerard.
Thank you for
sorry for
going over a little bit.
Thank you to both the speakers for sharing their knowledge and expertise on that field. If we have any questions and answers for them? Okay. I'll take the ladies first. You may introduce yourself.
Thank you. My name's Emma Hodge. I'm a European and UK patent attorney. Question about IPRs and how do they interact with HatchWaxman?
So, okay. I'm not a litigator, so there's no direct relationship. I actually was helping on an IPR where there was a parallel HatchWaxman case going, but we weren't handling the HatchWaxman side. But basically, I think the IPR is going to go forward if the case doesn't settle. So, you know, if you make your showing, it'll go forward. I think the question is, can you get the judge, or can you somehow stay the HatchWaxman case? But one's not necessarily dependent on the other. The HatchWaxman, there's a lot of other issues. You know, it's like a real litigation, full-blown litigation. But there's not a direct interplay, I guess, between the two. Did I answer your question, or?
Yeah, partly. But so the first challenger under HatchWaxman gets 180 days exclusivity.
Mm-hmm.
If a separate person challenges under IPR, would that separate challenge then have to wait for the 180 days and for the results of the HatchWaxman?
I'm not.
I mean,
I don't know the answer to that, because I don't get involved with the stays and all that. I know about the exclusivity and I have multiple filings, but that's not sort of my expertise. I don't know if there's anybody else. Do you know? Kirsten?
Well, I'm not sure I want to really get into that, but the 180-day exclusivity was in the past really a problem or a reason why many companies during that time didn't file any IPRs, so they waited until that was over. So,
And just as a related real quickly to that, if you want to clear a patent out, if you're say the generic, I mean, you can go ahead and file your IPR early on, you know, way before you would end up being involved in litigation. So you can use that as a mechanism to clear out the patent landscape before you're into this issue of actually filing and getting approval and getting sued.
All right. Thank you. Next question.
Hi, I'm Jay Samuels. I'm a non-bio patent prosecutor. Am I right that at the PTAB there's no presumption of validity and that's a big deal?
Yes, in district court there's a pretty high presumption of validity. You have to show invalidity by clear and convincing evidence. And in the patent office, the challenger has to show invalidity. So that's you know, legally that's should be a big difference, yes.
Any more questions? And I think that is it. Thank you.